Good morning, everyone. We'll give everybody about a half a minute to make sure we've got most of our delegates logged on to today's webinar, and we'll get started shortly. Good morning, and thanks for joining us for today's webinar. Today's webinar is about the MEA ACEC-Ontario Standard Engineering Agreement and how this can help your municipality. My name is Dan Cozy. I'm the Executive Director of the Municipal Engineers Association. Today I'll be moderating this webinar, and I'll do my best to make sure we stay on time. We will respect the times. I'm sure you all have other things you're needing to do today, so we'll be wrapped up by 11 a.m. at the latest. I'd also like to introduce some individuals that are going to be greatly assisting in today's webinar. We have Bruce Matthews, who is the Executive Director of ACEC Ontario. Bruce will be leading today's presentation and will be available to answer questions following the presentation. We also have Amanda Froese, who's the Director of Infrastructure and Development Services at the town of Saugeen Shores. Amanda also sits on the MEA Board of Directors, and she'll be supporting Bruce's presentation and will also be available to answer questions. And behind the scenes, you may see a photo of Amin Manina. He's the MEA's Member Services Committee. He'll be moderating the questions part of today's show. So briefly, today's agenda. First, Bruce, I'm going to turn it over to Bruce shortly. Bruce will lead us through roughly a 20 to 25 minute PowerPoint presentation. After the presentation, we'll have some time to take questions, and you can ask your question in one of two ways. You could use the question feature in Zoom, and I'm sure many of you or most of you know how to do that. Or you could raise your hand, use the raise your hand feature, and ultimately Amin will introduce you and we'll turn on your mic so you can verbally ask your question. We will attempt to answer as many questions as time permits today. If we do run out of time, if we have more questions than time permits, we will note any questions not answered, and we'll post those answers to our website in a few days. So when we get close to the end, I'll kind of give everybody a 2 or 3 minute warning, and if you're still waiting to ask a question verbally, you may want to go on to the chat function, the question function, write it down so that we have a record of it. We're also recording today's webinar, so if for some reason you have to leave the session early, you'll have a chance to come back and view it. So we'll post a link to the MEA's YouTube channel on the MEA's website, and you can always come back and see that. But it usually takes us 4 or 5 days before we can get that ready. So just a little introduction about the Municipal Engineers Association and who we are. The MEA is an association of public sector professionals, of full-time professional engineers employed by Ontario municipalities, or professional engineers employed by a branch of the federal provincial government, or related municipal organizations like conservation authorities, as well consultants acting as the engineer of record on behalf of municipality. We continue to grow, and we're proud to say that we're nearly at 1,000 members throughout the province, and we're very happy about that. The main sort of business aspects of the MEA, we're the co-proponent of the current municipal Class EA process in Ontario, and are currently involved in a major amendment Jointly with the MTO, we also manage Ontario provincial standards. We provide training for both the Municipal Class EA and Ontario provincial standards. And we also plan to start offering additional training programs on other topics in the near future. We also provide free webinars like the one we're doing today as a means to get information out there. And my office light turned off. There, I have an automatic light and it goes off every 5 minutes. We also work with fellow associations like ACEC Ontario to collaborate on issues of common interest. For example, the Standard Engineering Agreement we will be talking about today is a joint effort by both our associations and was initially developed back in the 1980s. And of course, it's been revised on several occasions to update it to current needs. We both endorse the agreement. So it's something we're both proud to offer municipalities throughout the province. And finally, I'd like to say that the MEA has approximately 40 different technical committees in various municipal engineering topics. If you are a member of the MEA and you want to get more involved in our association, please reach out to me. I'm sure we can get you more involved if you like. That takes care of my end of the show. I'd now like to turn this over to Bruce, who will tell you a bit more about ACEC Ontario, and we'll get started. Thank you very much.
Thanks, Dan, and good morning, everyone. Really great to have everyone here for taking the time this morning. I'm Bruce Matthews. I'm the Executive Director at ACEC Ontario. ACEC Ontario is the industry association for consulting engineering companies in Ontario. We are a member organization of ACEC Canada, which is the national level. They do most of their advocacy work sort of with the federal government, but each province and territory has its own level of an ACEC type organization. And our mission is to promote and advance the business interests of our member firms. So I'll contrast us with an organization like the Ontario Society of Professional Engineers, which looks after the interests of individual engineers, either who are employees of municipalities, of firms, of consultants, of manufacturers, and so on. But we're here to represent the interests of the actual organizations themselves. And as an industry association, we really have two primary thrusts. First is advocacy, which is government relations work at all levels of government, fully within individual ministries of the province, certainly the Ministry of Transportation, Ministry of Infrastructure, Municipal Affairs and Housing, but also at the regional and municipal level as well, trying to influence policy and legislation and so on as it relates to the interests of our member firms. And then the second thing we do, of course, is offer member service, which includes opportunities to engage in discussion and development as it relates to various business practice issues, including contract terms and conditions, the kind of things we'll be talking about this morning, but also allowing them to some networking opportunities, both amongst themselves and with various stakeholder organizations to establish connections and improve their overall business conditions. As Dan had alluded to, we've worked with the MEA for quite some time now, going over 30 years in terms of the development of this particular contract. And we also liaise with a number of other organizations. We're a member organization of the Construction and Design Alliance of Ontario, for example. So with that, I'd like to move straight into the more formal part of the presentation and talk about what is the MEA ACEC Ontario Standard Form of Agreement. It's a contract template. So rather than having to sort of reinvent the wheel on your own, what we have established jointly between our two organizations is a form of contract template that provides for what both parties agree, or both sides of us agree, are sound and equitable terms and conditions that relate to a municipality engaging a consultant for engineering services. The philosophy underlying this agreement is that it's rooted in fair and reasonable terms and conditions, and you're going to hear me use the terms fair and reasonable quite often throughout this presentation. And again, it's important to stress this was developed collaboratively between ACEC Ontario and the MEA, and it has had legal review. independently in terms of the terms and conditions. So this isn't an agreement that ACEC Ontario representing consultants have formed and are trying to thrust upon municipalities, nor is it something that the MEA has formed trying to be thrust onto consulting firms. It actually balances the needs of both. Primarily looking at obviously the interests of the municipality, but ensuring that consultants will be able to complete the work that's required according to the standards of the profession. I'll state from the outset, I don't think either of our organizations find this to be a perfect agreement, but where the imperfections may exist, they are balanced, and it is seen to be an agreement that is fair and reasonable and certainly durable for the purposes of the municipal works that a municipality may be contracting to a consulting firm for. So at this point, I'll have Amanda come in and speak to a little bit about why it is important, or why we believe it's important that this agreement be used. Go ahead, Amanda.
Thank you, Bruce. And yes, I work at a small municipality that doesn't have in-house legal. So for me, this is a great tool to use. First of all, it really helps my case for delegated authority to sign these contracts without them needing to go to council. So if it's within an approved budget, I can just sign up the consultant and move forward and avoid that delay. But overall, it really reduces the risk to the municipality because we have a signed agreement. If something does go wrong between the relationship, both parties are covered legally, and there is a way to appropriately end a contract or extend it through it as well. We like that it puts the expectations down on paper and clarifies who's responsible for the different pieces of the project, which also helps me pass it from project manager as staff members leave. And finally, the biggest advantage I find is it's something that I can use in my funding applications and in those funding agreements with the province and the federal government. So when I need to show to them the contract and the dates that they were signed to prove when we started spending the money, then I just use this PDF of our agreement. And that's what I have, Bruce.
All right, thanks very much. So Dan had mentioned that this agreement actually goes well back into the 80s. So I thought I'd just do a quick overview of the history of its development and its evolution. I think both of our organizations view this very much as a living document, recognizing that the legal and practice issues kind of evolve over time, and we want to make sure that the agreement is kept as up to date as possible. So it started, the first formal published version, certainly that I could track, goes back over 30 years and was referred to as a client/consultant agreement for municipal works. It was structured and written in the form of a memorandum of agreement rather than per se specifically a contract. So I found that was very interesting, but it did contain the same kinds of detailed conditions and information with respect to the nature of the works being done and the performance of those works, as well as information about fees and disbursements and the nature of the services. The next sort of evolution in early 2000s, in 2002, the two organizations introduced something called a consultant appraisal form that looks at the overall success of the project and the quality of the services performed on the project. I think ostensibly it was intended to be used for future evaluations of proposals, if you look at sort of an issue of qualifications-based selection and so on. But I'll tell you that I don't believe this is really in very wide use amongst municipalities. We certainly haven't really updated or maintained it, and I am aware that many municipalities or the major clients for engineering firms tend to have their own type of an appraisal or assessment form that they use to look at past project work for the purposes of future contracts. There was another edition in 2006, some minor changes made with respect to conditions and fees, but a fairly major revision made in 2016, and it was retitled as a client/engineer agreement for professional consulting services. So a couple of things here, by referencing rather than just municipal works, but professional consulting services a little bit broadens the scope in terms of how a municipality might use this. It was reformatted very specifically into a proper legal contract form, and throughout the document, the term consultant was replaced specifically with engineer. And then in the last few years, there have been some other evolutions. Thanks to technology, we've now been able to create this as a fillable field PDF format document. So rather than having to print off the PDF and then either handwrite or, heaven forbid, type in the specific details to fill in the blanks in the various boxes that exist, it can now be done straight on the computer through a fillable PDF, which is great. We have also jointly copyrighted the document, and the main purpose in doing that is to protect against what we'd call sort of minor tweaks and changes being done, and yet the overall form looking the same. We wouldn't want either side to be able to make a small change and yet have a document that looks very much like the standard form. So we do have a copyright in place. That being said, we know in the past some municipalities, and there's no real issue with this, would sort of block copy certain provisions and put into their own forms of agreement, and we certainly have no major issue with that. But in terms of the document itself being used, you can't go around making the small tweaks. And then, and we'll talk about this a little bit later, there was a user guide developed to provide for a little extra information about the nature of the terms and conditions and what these things mean to assist the end user of the document. Most recently, just less than a couple of years ago now, the agreement was updated to reflect changes to the regulations under the Construction Act that relate to prompt payment and invoicing provisions, and also to deal with aspects of dispute resolution, which is also called for under the Construction Act. And even as we speak, there is another iteration sort of under development. That being said, you are encouraged to use the currently available version on either of our websites, but we are looking at it to again ensure that it's modernized in terms of all the terms and conditions. Again, it's a rapidly evolving sort of field as it relates to contract law between municipalities and engineers. So we want to ensure that the document is as up to date as possible, reflecting any of the legal requirements as well as the industry standards. So with that, I'll spend the next maybe 10 minutes or so just talking about what are the key terms and conditions in the agreement. And there are 5 things that jointly, I would say, are some of the biggest headaches that occur in contracts between engineers and municipalities. We'd like to think if you're using this form of agreement, you tend to avoid those headaches, but obviously not everyone does. So we're drawing these to your attention. You'll note that in this list does not include the fee basis. I will tell you that the contract is flexible and provides for the engineering fees to be paid as a fixed price, or on a time basis, or on a percentage of cost of construction. So there's a lot of flexibility in that approach. And the other issue that's not specifically identified here that we might speak to a little bit later, maybe in the questions if there are any, is the issue of the standard of care of the engineer. There is a provision that relates to standard of care in the agreement, and if anyone has questions on that or concerns, we can certainly discuss that. But what we'd like to get into for the next little bit here is indemnification, dispute resolution, insurance requirements, intellectual property, and the concept of force majeure. So first and foremost, indemnification. This is the single biggest pain point, I can tell you, between engineering firms and clients generally, whether they're municipalities or other levels of government, or even frankly private clients. And indemnification essentially is a duty on the part of the party making the indemnification to make good with respect to any loss or damage incurred by the party to whom the indemnification is given. Anyone who is familiar with principles of risk management in the ways that risks can be dealt with, this is a form of risk transfer. So the municipality is able to transfer its risks associated with certain types of damages to the consulting firm. And the MEA ACEC-Ontario agreement specifically provides the municipality with indemnification based on any negligence on the part of the engineer. And this is really the important distinction. There has been a trend, and it's going to see over the last many years, but it's certainly getting a little bit worse now, is that municipalities or clients seek indemnification from the engineering firm for things that are either, one, outside of their control, which is problematic, as you might imagine, but also outside of the context of negligence on the part of the firm. And that's an important distinction because professional engineers and the consulting engineering companies, the professional liability, the insurance that they carry, which would cover this type of indemnification, is predicated solely on the issue of negligence. If there is a loss that happens that isn't an aspect of negligence on the part of the firm, then their professional liability insurance will not apply. So what we do see here is what I would call sort of, if you're not using this particular agreement and you think you're going to just simply transfer a whole bunch of risk over to the consulting engineering firm by asking for a very broad sort of indemnification, that there's a caution I would raise with respect to, you don't want to have an indemnification that isn't backed by insurance. Honestly, any indemnification in a contract is really not of a great utility if there's not insurance to back it up, because the question that becomes, if something goes sideways and you incur damages and you seek to be compensated for those, if there is no insurance in place, the question becomes, what action can a municipality take? You could try obviously suing the engineering firm, but I'll tell you, the firms don't have necessarily deep pockets, so it may very well be that the municipality is on hook for those things anyway, because it would be otherwise be an uninsured on the part of the consulting firm. So it's really important, and we really do try and stress to all of our member firms to ensure any indemnification they undertake is going to be based on negligence and therefore will be covered by the professional liability insurance that they cover. Now, the nice thing also about the MEA ACEC-Ontario agreement is that there is reciprocal indemnification provided, in that, yes, the consulting firm indemnifies the municipality with respect to any losses and damages that result from negligence, but the municipality also indemnifies the consulting firm on a very, very narrow basis with respect to essentially exposure to hazardous materials is really what it provides for. But at least there's an aspect of reciprocity there. Moving on then to the idea of dispute resolution. Again, this agreement having been negotiated mutually and cooperatively, we've provided for a mechanism sort of escalating elements of dispute resolution, and it sees it as a very much a sort of cooperative and collaborative work. I think everyone agrees when you're entering into a contract, nobody wants the contract to go sideways, nobody wants disputes to occur, and you try and do your best to avoid them, but nonetheless they may happen. So this form of agreement provides initially for an element of negotiation for both sides, just sitting across from each other at a table and working out the nature of the dispute and trying to find a mutually agreeable resolution. Things may come up that just weren't contemplated in a contract or whatever. If for some reason the negotiation can't reach a mutually acceptable resolution, then the contract would call for a mediator to be brought in and a mediation period to take place. And if things have really gone south and the mediation doesn't result in a solution, then the contract does call for a binding arbitration. So the idea here is you've got methods that are available that ultimately avoid actual civil litigation taking place. I've done a lot of work with lawyers, and everyone tells me that civil litigation is neither civil nor actually does it all that much litigation involved. You tend much more time outside of courts, doing depositions, doing things that are frankly costly and very time consuming when you've engaged the lawyers for that purpose. So both ourselves and the MEA agree that is to be avoided at all cost, and therefore providing, as an end point, a binding arbitration process, if it was to get that bad, still avoids you getting into a court situation. So again, we think that's to the benefit of both sides. Next issue we'll talk about is insurance. The contract does provide sort of a fill-in-the-blank type setup for the levels of general liability, automotive, and professional liability insurance that would be required to be carried by the consulting firm. It does note specifically that those coverages amounts cannot be changed or otherwise canceled without written notice between the parties. So that avoids a situation where a consulting firm, frankly acting nefariously, would have insurance in place at the time the contract is signed, but that insurance either expires or gets canceled somewhere during the course of the work to save themselves some money. Clearly an unfair, unreasonable thing to have happen, and therefore is again provided that should not happen in the context of this particular agreement. It is important to note that the insurance provisions in this contract do establish a limitation of liability on the part of the engineering firm, and that limitation of liability is set at the amount of insurance that is specified in this particular clause. I do note that we've seen a trend over the past few years of increasing minimums being required by municipalities and by clients for consulting firms. What used to be, if I go back far enough, I suppose even, a $500,000 coverage was kind of a default, and then bumps to $1 million. Most recently has been 2, and now there's a number of jurisdictions bumping that to 5. Personally, I've got sort of 2 comments on that. One, by increasing the insurance requirements, you may be leaving out a number of firms who just decide that they don't want to carry that level of insurance on a full-time basis when there's only 1 or 2 contracts in the course of a year that may require it. So your pool of available resources may be artificially lowered by unreasonably high insurance requirements. And then secondly, trying to ensure that the levels of insurance are frankly reasonable in the context of the work being done. If it's a small $10,000 fee project, requiring $5 million of liability is kind of strange. What do you think is possibly going to happen in a smaller type project that's going to require that level of liability? So the fact again that these are blanks to be filled in on a contract by contract basis, and really should be based on what are the needs to properly ensure that the coverage is in place. The contract does provide for other forms of insurance to be required that can be written in, and it does specifically state that the cost of any additional insurance that's required will be borne by the municipality. It'll just be a direct cost inserted into the contract. One other comment just with respect to, again, the levels of professional liability insurance that may be sought. And I fully appreciate that these costs are flow through to the client. So a municipality, when they increase their minimums from $2 million to $5 million, should very well be expecting to be paying more for the engineering services as a result because of the higher cost to the consulting firm. So as long as everyone's got their their heads on straight with respect to that, you can't expect to be increasing liability, professional insurance requirements without some associated cost with doing that. And even honestly, costs of insurance have been increasing, over the past few years. There's some challenges, especially in the Ontario market, with respect to professional liability for professional engineers. So this is an area to be approached quite carefully. Next item deals with intellectual property. And this is a fairly straightforward matter. Generally speaking, in the contract, any of the intellectual property developed by the engineering firm remains the property of the firm, but the municipality does have what's referred to as a permanent, non-exclusive, royalty-free license to use that intellectual property in connection with the project in question, but it can't be done for any other purpose. And the example I would use there is, let's say you're engaging an engineering firm to design a storage facility. Doesn't matter what you're trying to store, but it requires some sort of custom design work. And that project is for a storage facility at 123 Main Street in your municipality. And that project gets done. And then you decide as a municipality, you know what, we need another one of these things, but over at 123 10th Street. You cannot simply take that design and duplicate it. It's again, the design itself applies to the engineer. All the drawings, et cetera, that are done were issued for the purpose of the project at 123 Main Street, not anywhere else. So again, if there's a desire for the intellectual property to become the property of the municipality, that's a very different sort of thing that would require some notable modifications to this agreement. And then the last one I'll talk about here is the idea of force majeure. This is very relevant to our current times. We strongly prefer to see a force majeure type clause in any contract between engineers and their clients. And in this one essentially says that the engineer is not going to be responsible for any damages or anything in terms of delays that are caused by things that are outside the control of the engineering firm, be it a labor dispute, severe weather, natural disasters, etc. And the question has often arisen here in the last year as to whether, well, does a pandemic count for force majeure purposes? And I'm not a lawyer, and I'm not going to opine specifically if that does. But what I would rely on in this case is the language that speaks to other emergencies. So as you'll know, that the province of Ontario declared a state of emergency when the pandemic first broke out, and subsequently declared another one, and I forget when it was, either earlier this year or late December, I can't quite recall. But if the province is in a state of emergency, it strikes me as reasonable for an engineering firm to be able to rely on this force majeure as a state of emergency going on, that if there are delays that cause damage to the municipality, it's not going to be on the engineer. And then the other element of this force majeure clause is that, again, from a pure, fair, and reasonableness point of view, if that delay that is not their responsibility causes a change in the schedule and or increased costs on the part of the engineer, that there would be reasonable compensation associated with those two things. And again, the contract doesn't enumerate very specifically what that is, but it does just provide generally for that ability for the engineer to be compensated reasonably for additional costs as a result of schedule change and or other activities that may be required associated with that type of emergency or other force majeure matter. And again, if there were concerns, then there's obviously a dispute mechanism in the contract as well. So those are the main bits that I did want to cover off, and did want to bring to your attention that in addition to the actual form of agreement itself, our two organizations have developed a user guide that will assist in a municipality and or an engineering firm's understanding of the particular provisions, and it does cover off. This user guide is quite comprehensive in providing clarification and guidance with respect to all of the individual clauses that exist in the agreement. So all of the different terms and conditions are explained, and it does provide rationale for why those various things are in the agreement. So it's a really nice thing if you haven't got much of a legal background, or if, as in the case in Amanda, you don't have a legal department. This is a good supporting document that you can use to help you understand the kinds of things that are included, and it may even provide you some information that's going to assist in terms of filling in the blanks, because as I say, there's a lot of stuff here. It's a template agreement, a lot of things to be filled in on both sides. So this document can also help. In terms of where can you actually find the agreement, both ourselves at ACEC Ontario and the MEA, we host the standard agreement on our websites. It is free to download and can be found at the links that you'll see here on the page. I believe, Dan, and we're going to make the slide presentation available to folks afterward, or at least the recording is certainly available. So if you haven't got time to scribble those down, just take the information with respect to the main website. You could do a search on either of them, and you'll quickly find the standard agreement. So that's as far as I wanted to take things for this morning, and happy to open up for questions. And Dan, I'll turn it back to you as the moderator.
Thanks, Bruce. Yes, good presentation. Thank you very much. We do have at least a couple of questions on the Q&A function. I'll turn it over to Amin, who can advise us if we have a queue of any hands raised, people who want to ask their question verbally rather than write it down. But let's get going with the questions, Amin.
All right, thank you, Dan. So the first question is, has there been any consultation with municipal insurers on the liability coverage issues? Usually staff are stuck in the middle of the insurance argument, as our insurers default to suggesting a minimum coverage. If we don't follow the insurer's recommendations, it's on us if something goes wrong. So to sum it up, that's a long question. Has there been any consultation with municipal insurance on the liability coverage issues with regards to this standard agreement?
Dan or Amanda, are you able to speak that out? I know on the consultant side, we've had legal review and including review of lawyers that work with the various insurers. But again, that's looked at very much from the consultant's insurance and liability side. I must say off the top of my head, I'm not quite sure whether there's been consultation with municipal insurance providers or not.
For my experience, Bruce, we looked at the agreement sort of project by project and went a few years ago back to our insurance provider personally and said, for this type, we want to ask this level and what's the risk of that and what's acceptable to our insurance company. So we have a set number. So like we have 2 million we can do for some smaller jobs and then 5 million for any large construction. And that was just based on our personal insurance company.
And that strikes me as a really, a reasonable approach is, speak to you if you've got concerns from municipalities, speak to your insurer and see what they say.
MEA is also cognizant that we don't want to tell municipalities what they should be, mandatory, what the insurance requirements should be. So there's an understanding that each municipality can customize the insurance as to whatever they believe they need. But as Bruce indicated during his presentation, there could be ramifications of doing that. Like you said, you may shorten the list of available consultants if you're going too far with the insurance requirements, et cetera. And of course, then there's the overall cost associated with it. So there's been some discussion with the insurers, but generally we leave that to the municipalities to decide.
All right, thank you. The next question is, please elaborate further on how the design remains the properties of the design engineer when they are receiving their fees for the service.
Right. Well, and that's actually a really well-phrased question. So the nature of the contractual agreement under this form of agreement is the municipality is buying engineering services. Right? It's taking the work of the professional engineers, but it's not necessarily buying a product. Right, so that's the distinction I would make that's important here is that yes, you're getting the services, the engineer is bringing their skills and knowledge and diligence to the work, but the ultimate end product in terms of what's being created doesn't belong to the, well, excuse me, I'm sorry, I should circle back on that. The municipality can use the drawings and the other bits of product as a result of that services for the initial application as defined in the project itself, but for no further purposes. Clearly, well, in most cases for municipal works, the work of the engineer is going to be handed off to a constructor, and of course the municipality owns the building itself, the structure. And if you take that storage example I was saying, yes, the municipality owns the actual storage shed. There's no issues, concerns there, but the underlying intellectual property of design under the way this contract is worded belongs with the engineering firm. And again, we've seen other contracts with municipalities and other large clients where they wish to actually own the intellectual property as well, which is not necessarily problematic, but it's going to factor into fees and approach and so on. A lot of concerns if a municipality uses an engineer's design without the engineer being involved as to where aspects of liability come. So those are some of the issues that come into that.
Thank you, Bruce, for the detailed answer. For the person that are asking about the slides deck, yes, we will make that available as well as the recording. So the next question after that is if the standards are developed by the consultant, whether there will be any bias towards their own interest.
Not sure what standards we're talking about in that context.
I wasn't sure either. So, Brindra, please rephrase your question, and we will get to it. So, jumping on the next question after that. On the standard agreement, when choosing the payment method 331 and 3.33. seem to be linked. Can you not choose the option of does not apply for one that does not change the other?
Well, so 331 is the idea of fees calculated on a time basis. 333 is the idea of a lump sum fixed price contract. Those two things shouldn't be linked, so I'm not quite sure where the issue or concern is. If there's something in the template that's defective, certainly we'll attend to that. But yeah, generally speaking, you're going to get one form of fee-based calculation for a particular contract, and it would be one of those three that I mentioned. It's either the time basis, which in some contract language people talk time and materials. And again, materials are often a less of an issue for consulting engineering contracts, but certainly the time for and certain expenses that are there, as opposed to a lump sum, which of course minimizes the risk on the part of the municipality. And then again, less used is the fees calculated on the percentage of the cost of construction, different kind of project application for that. So again, not sure where those two things, all three should be seen as independent. And I'll just use this opportunity to mention that ACEC Ontario last year introduced a fee guideline for the setting of consulting engineering fees. It's a document that's actually intended equally for engineering firms as well as for clients. So if you want to get a better understanding of how it is that consulting firms arrive at the fees that they set under each of those three sort of categories, I would invite you to go to our website, acecontario.ca, and have a look at that fee guideline. Just do a search under fee guideline and it'll pop up quite quickly.
Thank you, Bruce. Another question is asking, can you comment on if municipalities or major municipalities have been consulted during the development of this standard form of agreement?
Dan, I'm going to toss that one to you.
Sorry, I was muted there. The question is about the insurance, the auto coverage. Sorry, which question are we dealing with here? Sorry.
Yeah, this is the one that has to do with.
I'm gonna restate the question. Can you comment on which municipalities, or have you involved any municipalities in?
Sorry, I was looking ahead at another question. I also note, Amin, that we have a few questions on the chat function.
That's what I've been reading.
Okay, that's why okay. Not that I'm aware of. I mean, I sat on the MEA Board of Directors from about 2010 to 2017, 16, something like that. And I was involved in some of the iterations here of the agreement. We've generally posted the agreement to our website. I don't think we've formally asked for comments because we felt that we were representing the interests of the engineers of the municipalities who actually use this thing. So no, I don't think we formally asked for comments from municipalities because we really believe that the prime market for this agreement are those smaller and perhaps medium-sized municipalities. I mean, let's be honest, places like the City of Toronto and the big places of York Region, they have their own legal departments, and they're going to probably have their own form of the agreement. So we believe we represented the engineering industry in the target market for this.
I see. Thank you, Dan. The second question is regarding a specific clause in the agreement. So I will go ahead and read the clause and then read the question. So in this statement that says, invoices will be due and payable as presented without holdbacks by the client upon receipt and in any event no later than 28 days after receiving the proper invoice. So that is the statement. The question is, the term without holdback, that indicate that municipalities will not hold 10% statutory holdback?
I think the short answer is exactly yes. That's exactly what that clause is intended to say, that the invoice amount is going to be paid in full with no amount held back.
All right, thank you, Bruce. The next question after that is, we are starting to see owners keep 10%. Oh, it's a comment, I guess, or follow up on that. We're starting to see owners keep 10% holdback for engineering services. What are your comments on this?
Yep, I'm going to say we're seeing the same thing, and that's tied a little bit to the amendments to the Construction Act that I mentioned during the course of the presentation. There were regulations under the Construction Act that had to do with invoicing and prompt payment and so on, that did ultimately capture certain types of contracts between municipalities and consulting engineers as part of that regime. And under that regime, yes, holdbacks can be held. And in fact, it is my understanding that engineering firms have the ability to lien then against a project in the context of those holdbacks. So it just provides, it's a different regime, and perhaps maybe at some point in the future we should really do another presentation that speaks to the Construction Act and some of these challenges. I don't want to get into all the details here, but it's a different world now than it was prior to those changes, where in terms of what is possible, doesn't mean that you have to do it per se, but yes, it's allowable for the holdback to be taken. Clearly, if assuming it's in the provision is in the contract itself, and it's also possible for the engineering firm to lien against the municipality regarding that holdback.
Thanks, Bruce. So referring back to the question by Borindra Sanyal regarding the standard form of agreement and comments on it, is it being biased or not? His question was restated in the standard form of agreement, which is developed by ACAC. I can jump in and correct it here. It's not by ACAC alone. It's a collaboration between ACAC and the Municipal Engineers Association. So going back to the question, is that agreement, will it be biased towards contract consultants?
Okay, so that's a fair question, yeah, and I tried to stress at the outset that indeed this agreement is jointly developed with interests on both sides, the interest of the municipality being covered through MEA, the interest of consulting firms being covered by ourselves at ACEC-Ontario, and both of us recommend and promote this as a fair and reasonable agreement. And again, the words I would use that are important here is balance. There are a balance of interests, and as I said at the outset, it's not perfect from the eyes of the consultants, it's not perfect from the eyes of the municipality, but where those imperfections exist, the fact that you've got an entire agreement which is acceptable and in fact encouraged by both organizations, I think you can not be concerned that somehow there's any sort of bias in any of the particular provisions here. Again, recognize that this is a template. There's an awful lot of fill in the blanks that can help, for lack of a better word, tilt the table if there are some concerns that way. And it's obviously still up to the municipality to fill those in, because it's typically the municipality that's going to be presenting this as their form of agreement. It's usually not going to be put forward by the engineering firms directly. But if you're using the standard form of agreement, at least the engineering firms should be aware of what the structure is and what the provisions are. But indeed, yeah, I would argue any concerns about it being biased one side or the other are unfounded, because it is a mutually developed agreement.
I would totally agree with what Bruce just said on behalf of the MEA. The MEA represented the interests of the municipalities, and the ACEC, of course, was looking after the interests of its member associations, and we collectively arrived at what we believe was fair and equitable agreement. I'd like to just note there's a bunch of questions being asked on the chat function. We would prefer you actually ask your question on the Q&A. Some of them have been answered by some of the panelists. Some of the chats have been replied to. Mike from Wasaga Beach, how are you? You made reference to the short form agreement. I just want to sort of advise, there used to be two forms of the agreement back in the day. There was a short form and a long form. Now we only have the one type. So please, you may be looking at an old version, Mike. I believe Amanda's given you the link in her reply. But if you go to our website, there's just the one form now that you should be using. Hopefully that clarifies it. Mean, handed it back over to you, and we have we're 10 minutes to 11. So let's see if we can get through as many questions as we can in the next 7 or 8 minutes, and then I'll just do a quick conclusion here.
Thank you, Dan. The next question is also touching back on the 10% holdback. What is your comments regarding how that fits with the Construction Act?
I'm not going to claim to be an expert in any way with respect to the Construction Act. We've got someone else in our organization who's been sort of on that file for longer than I have. But again, my understanding is that the Construction Act does allow for holdback to be held in contracts that exist for construction type projects between municipalities and consulting engineers. And I know there's still, I'm going to call it a gray area right now, where it may take some lawsuits to ultimately to work this out as to what is the scope of the project that would ultimately fit within the parameters of falling under that Construction Act. So if you're doing just a preliminary study, does it still qualify? And I'm not going to opine one way or the other than to say it's a question for which perhaps some additional legal information should be sought. But assuming the nature of the contract and the nature of the work falls within those provisions of the Construction Act, then that ability to include in the contract a requirement for holdback, it can't necessarily be argued. Again, it doesn't have to be there, and it can be negotiated otherwise, but that is something that is allowed for.
I see. And the next question is also related to that. It may have the same answers from you regarding the prompt payment for consultant agreement. Is it similar? Is it the same as per the Construction Act?
Again, short answer is yes. So the expectation would be that the prompt payment provisions that are called for under the Construction Act would apply to contracts between municipalities and consulting engineering firms as they relate to the kinds of works that are contemplated under the Construction Act.
Thanks, Bruce. So one person is asking or commenting that we have an agreement set up with lump sum for base work, but then work on time and material basis for construction review and additional work. How should we set up the agreement for that case? So they have two kinds of agreements: it's lump sum and then time and material basis for construction review and additional work.
Yep, it's a fair question, and I think what you're looking at in that circumstance, and I'll have the person correct me if I'm wrong, but essentially two phases of work. There's the pre-construction element where a lot of the design work takes place, a lot of the development of specifications and drawings and so on that'll be used for the purposes of the construction. And then acting on behalf of the municipality during the course of a construction with respect to contract administration, general review, construction, all those sorts of things that come into play. I would say if when using this particular form of agreement, you may want to consider that two separate contracts. The first one dealing with the design effort, that's at the fixed price, and then one that covers off the general review construction and other construction related activity on the time basis. That might be the best way to do it. Otherwise, it does, again, the way that this template exists, it sort of contemplates one version of a payment structure rather than multiple. So it gets a little bit challenging to try and encompass both of those under one contract.
Thank you, Bruce. The last question I have here is, what is the main resource for the clients in case of delays from consultant firms?
The question was, what's the main recourse for clients in case of delays from consulting firms, Bruce?
Yeah, well, clearly, ideally, the contract is going to contain some schedule information and some milestones or deadlines. If those things aren't being met, then that's a concern under the contract, and I would start with the dispute resolution process, is to sit down at the table with the firm and talk about what's going on. And not every delay necessarily results in a cost or damages to the municipalities, so it's got to be put in that context as well. But your first recourse is directly to the consulting firm under the terms of the dispute resolution to address that. Amanda, I'm not sure if you got other perspective on that, but that strikes me as the as your first stop anyway.
I agree. I would say dispute comes up so rarely. I have never experienced it myself, but just like any other negotiated contract, you try to come to an agreement before you move down that stage to the next stage.
Yeah, I mean, that it does sort of stress the importance of the details that are part of the blanks to be filled in here, that relate to aspects of both scope of work and schedule as well.
Yeah, schedule becomes really important for us with the funding. So for Connecting Links funding, it's one that we really need to push, because we will not get the money in the end if the consultant doesn't stay on schedule.
Okay, we're just getting down to sort of the 2-minute warning here. I'll ask the last question. One just came up. And Bruce, if you could address this one, and then we'll call it a day. How would it be best to deal with out-of-scope costs to amend the agreement? Would you amend the agreement for new items?
Well, actually, I think the question almost answers itself. If there is something that's outside of scope, therefore not really falling within the four corners of the contract, you are looking at making an amendment to the contract itself. And there's nothing, I think, that prohibits going back and making changes to the scope as described when something unexpected arose, perhaps. And of course, once you're reopening the contract in terms of scope, you might be reopening it in terms of the pricing part as well. So I think, to me, the most straightforward way of managing that is just through a mutually agreed amendment to the contract.
Okay, quickly, one just came in. Is there a markup cap on sub-consultant services?
Under the contract, no cap. So it's really a matter of that's an item to be negotiated between the two sides.
Okay, we're going to close the floor now. I do want to take this opportunity to sincerely thank Bruce and Amanda for participating in today's free webinar. The MEA would like to continue offering webinars like this in the future. For those MEA members out there who may be interested, Bruce and I will actually be working on a free webinar on the excess soil regulation. That's something that's going to be coming up and I think of very much interest to our members. That's something we're going to plan for in either Q3 or Q4. Some other things may come up. I believe we have a free webinar, Amin, on with Concrete Ontario in about a week, if I'm getting my dates right.
Yeah, that one has been postponed to June.
Okay, all right. And so we are trying to provide these free webinars wherever we can. Of course, we have other training sessions on the go. We recently held our OPS 101 course and via webinar, and we're offering our introduction to the municipal class environmental assessment at the beginning of June. If you're interested in that, please go to our website and register for that. Once again, thanks to Bruce and Amanda. Also, thanks to you, Amin, for helping us out behind the scenes. Amin's our technical guru, help us old folks here with all this technology. On behalf of the MEA, thank you for attending. Stay safe and stay well, and we hope to see you again soon. Take care.